The only avenue you have is to go through a land court process, which is known as a petition to partition, which runs about a year to 2 years and probably would cost somewhere around $50,000.
Holy cow. Okay.
So not a pleasant process.
No. They might consider purchasing a home with a non-relative, even if it's a boyfriend or girlfriend and they're not married yet and they haven't got plans right now. Welcome to the Real Estate Solutions Lab podcast. I'm your host, Tony Cardinali, and here we tackle all kinds of things real estate, whether it's transactional problems, property-related issues, anything specific to a buyer purchasing a home or selling a home, even daily homeowner issues that we tackle it here. And today I'm really welcoming a great guest and friend of mine, Philip Eliopoulos of Eliopoulos Eliopoulos PC. He's an attorney here, real estate attorney, estate planning attorney. I've known Philip for years and years. We've worked together hundreds of times probably. And so I've come here today with some specific subjects to talk about. And before we dive into, I wanted to introduce you, Philip, to everybody, so that people have a context to what kind of background and experience you have. So I wrote down a quick introduction to go through, but we're also going to talk about a few subjects that have come up in my recent past, if you call it a year past recent. And I can go through those as well. So let me first introduce you to our whole audience here. Our guest today is Attorney Philip Eliopoulos, founding partner of Eliopoulos Eliopoulos PC, with an impressive career spanning two decades. Philip has established himself as a versatile legal expert with a focus on commercial and residential real estate, business and civil litigation, estate planning, elder law, zoning and land use, and family law. So Philip's journey began in Boston College, where he earned his BS in Business Administration with a concentration in finance, and he went on to receive his JD at Suffolk University Law School. His early career include handling commercial real estate transaction for Compaq, formerly known as Digital Equipment Corporation, and later joining a firm in Chelmsford, Massachusetts, where he honed his expertise in various legal domains. So in 2000, Philip founded Eliopoulos Eliopoulos PC. It's a general practice law firm, now run by his sister and partner, Angelique Eliopoulos. Philip's commitment to his community is just as remarkable as professional achievements. He served as on the Chelmsford Board of Selectmen for 12 years and continues to actively participate in numerous local organizations. Today, Philip is here to share his wealth of knowledge on navigating the complexities of real estate transaction and legal disputes. And whether you're a first-time homebuyer, seasoned real estate investor, real estate agent, or you're just facing some sort of legal challenge, this episode is going to be packed with really good information for folks. So today I'm going to introduce Philip. So thank you very much for coming.
Tony, thanks for having me. It's a pleasure to be with you as always.
Our pleasure. Always good to talk with you. And I got to see you this morning too. So that was a plus for me. Today I want to introduce a couple of topics to you. Now these topics have come up in my career. I've been doing this 22 years, and there's been a number of times where I've had these two things come up. But I think today it's going to be a great treat to hear from a professional who can summarize these topics together into one. So the first topic that we're going to talk about today is something called joint ownership. Something called joint ownership for non-married borrowers and buyers. And so you think of this as like people that aren't married that are buying a home together. What are the legal issues that might come up with that? And we're also going to talk about the effects of divorce on property title. So I'll go into a little bit of a story on that because I had something last year happen with that. So let's take these one at a time. And if we can talk first about the joint ownership for non-married borrowers, this actually came up last week. I had a buyer come to me on Tuesday, referred to me from a real estate agent. He was a first-time home buyer, and with the expensive properties today, they really can't always afford the property on their own that they're really looking for. And so this person had the idea to add a friend. He didn't have a co-signer. He didn't have a parent or a relative that could co-sign or co-borrow with him. And so he decided to find a friend that wanted to also buy a home, and they decided together to go in and potentially purchase a home. And I imagine this brings up some legal challenges if, God forbid they ever want to split ways later and don't like each other later if they're not friends anymore. Can you share with me a little bit more about what kind of problems this presents?
Sure. Yeah, it's great topic. So I think you're seeing this more and more over the years.
Yeah.
20, 30 years ago, you almost only saw, married couples buying property. But I think people are in relationships. They're not running to the altar, but they're in a committed relationship, and they sometimes want to buy real estate together. The issue is if there is a separation, if there's a breakdown in the relationship, unlike a married couple where you can go to divorce court and figure things out, you can't do that as two, just unmarried co-owners of a piece of property.
Right.
The only avenue you have is to go through a land court process, which is known as a petition to partition, which runs about a year to 2 years and probably would cost somewhere around $50,000.
Holy cow. Okay.
So not a pleasant process.
No.
So, there is, for lack of a better word, an agreement we can put together. It's really almost like a prenuptial agreement, but for couples that aren't going to be married but that are buying properties.
Interesting.
I call it an operating agreement. It's a very simple, 2-3 page document that would cover those what ifs that you sort of raised. Hey, what if this doesn't work out and one of us wants out of this situation?
Wow. So this is only if they're potentially disagreeing with each other in the future and they don't agree on selling the home or, just parting ways and splitting things easily. And very often I bet that can happen where they're not agreeing on something. Is that right?
Yeah. So it's like anything. It's if while things are going well, like let's say you and I want to go into business together, we're going to start a new business.
Right.
That's the time to do some type of agreement that talks about, all right, everything's going great, but what if?
Yeah.
Because we can reach those agreements when we're happy and enthusiastic and we're looking positive on the situation. Once things break down, it's sometimes near impossible to reach agreement.
Yeah.
So, if we put together something up front, we can not only cover those what ifs down the road, but we can also document how things are going to happen in the short term.
Okay.
We're going to apply for a mortgage with Tony.
Yeah.
We're both going to be on the hook for this mortgage. How are we going to pay for it? Who's going to be responsible for the monthly payments? What proportion are we going to make those monthly payments? So we can kind of get into not only maybe how to unwind it, but how do we make this work and how will it work from day one?
Interesting. This that's interesting. You bring that up. It brings up a situation I had where two families purchased a summer home together. And they purchased it together, and then later one of them wanted to get out of the summer home, and they needed to go buy a primary residence. And as a lender, I got to look at who was making the mortgage payment was important at the time.
Right.
In the future. At the time, it didn't matter because they would just all give this one guy that turned out to be my client in the future all the money, and he would write the check out of his checking account. Well, that turned out to be really hurting him, because he wanted to buy another home without selling this summer home first because the people were still in it. And they didn't have time to go through this whole agreement thing. So I was hitting him with the entire mortgage payment on their departure, whereas he could not purchase another home. He had this huge mortgage payment on the books. So with an agreement in place where they were splitting the cost together, maybe paying half of it out of their checking account, maybe would have made things easier.
Right. And those are things to consider, right? How will these payments impact our future?
Yep.
I didn't even think of that. So that's a phenomenal point that you brought up, that if we just do it for convenience, I'll pay you and you pay the mortgage, and that becomes the history, then that might affect me when I apply for another loan someday. So great thing to think about.
Yeah.
The other thing we might cover is documenting how much of a down payment each side put in, right? Because, maybe I've got a little bit more money. I put in 20 grand. The other person puts in 10.
Yep.
And then 3 years, 5 years later, do we remember what we did? Can we document what we did? How did we agree that was going to get handled if we sold the property?
Right.
With property comes responsibility, comes upkeep, right?
Yep.
So within the agreement, we might discuss how are we going to decide on improvements, repairs, who's going to pay for them,
Yep.
how are those going to get reconciled if and when we sell the property.
Okay.
So we can talk about those things in the agreement as well.
So walk me through, like, are there, you just kind of brought up a few things. Obviously, if things don't go well, how do we split things up? What is the game plan ahead? Let's think ahead of time of what the game plan is if things don't go well. But there's also the agreement of what do we do during our ownership, our joint ownership of this home? Who pays who pays the mortgage monthly, or who's on the hook for the electric bill? Who's going to put that in their name? So what would could you cover for us sort of the big things to think about in that area, operating expenses, future?
Yeah. So when we think about the basic payments, we think of certainly principal and interest payments on the mortgage, the real estate taxes, the homeowner's insurance, certainly, ongoing maintenance costs, cutting the lawn or painting the house.
Right.
How are those going to be decided? What if we can't agree?
Yeah. What if one of them puts a lot of labor in and starts feeling like their sweat equity deserves? Can you actually cover that somehow in some?
We
sort
can,
of
and this agreement can always be amended or addended. So let's say they say, "Hey, listen, we didn't foresee having to fix the roof."
Yeah.
And I don't have the funds, but my partner does. Can we put some simple addendum or amendment to the agreement that says, if and when we sell it, he'll get the 20 grand back?
Right.
So that might be, we can, and they can even do it on their own, just so it's in writing documented so that there's something that says, hey, this is what we agreed to 3 years ago on this particular issue.
Very interesting.
Because it is hard to know everything that, foresee every little thing.
Yeah. Okay.
But, and it might be too that it's a breakdown by, not by design, but by circumstance. What if someone passes away?
Oh, yeah.
You and I go into business together.
Yeah.
We're going to own this property together.
Yeah.
You pass away. I'm picking on you instead of myself. And now you've got your spouse. Do I want to own property with Tony's spouse? Maybe I don't want to own property that way.
Okay.
Right? And so there's a critical piece that we talk to our clients about, and it's really the form of tenancy that we're going to put on the deed.
Okay.
There's really two types of tenancy that we can look at when unmarried couples or people are buying property. It's tenants in common and joint tenants with rights of survivorship.
Okay.
Not to get too much detail, but tenants in common means if you and I own property together and one of us passes away, your half goes through your estate to whoever you want it to go to. And joint tenants with rights of survivorship means if you pass away, your interest in the property vests to me. Mm-hmm. Now, that might make sense sometimes if you and I are taking out a loan together. Mm-hmm. In other words, if I'm going to be the leftover candidate, then I'm the one who's responsible to pay cross-country mortgage the loan back.
That would be the case. Good point.
So in some ways, it makes sense for the property to go to me, and because I'm inheriting the debt and the liability.
Right.
But what about the equity that Tony's put into this?
Yeah.
So, we can cover that in the agreement. We can decide what tenancy they're going to take.
Yep.
And if joint tenancy makes sense because they are taking out a mortgage, we can cover that the survivor would still be responsible for paying some over a period of time, if need be, the equity for the deceased owner.
I didn't think of any of that.
Yes. So these are things like, you think of these issues that could arise. And so even something as simple as how the deed is drafted is going to be critical to this type of agreement.
And it likely makes the most sense that these are individuals purchasing the property. They don't form an LLC of any kind or anything like that. It just really that would get expensive and complicated, difficult to lend on.
Right. I think it would be lending issues. Yep. I think it becomes, especially if they're going to live there, do we need the protection of an LLC?
Right.
But it's almost like not having the LLC, but having the shareholders agreement beside the LLC, having the, you know what I mean? So within any, corporation, you have the papers that created with the state, but then you also have the agreement amongst the owners. And so really that's what we're covering is the latter part of that issue.
Wow. Fascinating subject. And I think even more timely today where people are looking for ways to afford homes. They're having difficulty affording homes themselves, perhaps, especially as first-time home buyers. And they might consider purchasing a home with a non-relative, even if it's a boyfriend or girlfriend and they're not married yet and they haven't got plans right now. Even having something like that thought about ahead of time. I probably have a lot of people to send you because it's happening a lot.
and just to sort of wrap up what we can cover, we can even get into the detail of if they decide to sell it, who they're going to use for a real estate broker, that they maybe use the same broker that sold them the house so that they're not fighting over what real estate agent to use later on. So we will get to that level of detail so that almost every decision we can think about possibly pre-making we'll make so that there's not a whole lot to fight about at the end.
That's fascinating. Thank you. Thanks for sharing that. So this brings up talking about stuff that has happened to me before. It brings up another subject or story that I've run across. This was last August actually when a home buyer came to me. And they were purchasing a home. They were out there, got them pre-approved. They're out there shopping and they make an offer on a home and it gets accepted. And, we don't know anything going into the transaction, but in the very early part of the process, we start seeing some warning signs. And it turns out the seller of the home had gone through a divorce. And potentially, I don't remember if this one was in the divorce because I had another one afterwards. Things can come up during a transaction when there is a divorce happening. I imagine that we got through our transactions just fine, but these were situations where it can drop in your lap potential problems with the contract or title or anything as we go through the transaction, try to settle smoothly and on time. Share with me what you can about buying a home when you're purchasing it from a seller in a divorce situation.
Okay. I think there's two things to be aware of, and they're sort of separate topics. One is the seller that might be in the middle of a divorce.
Right.
The other is a divorce that maybe occurred and is finalized somewhere in the seller's chain of title, either the seller or the prior seller.
Okay.
And the reason is that divorce is a court action, and through that court action, it can create rights in non-titled owners. So I'll give you a perfect example. I had a situation where parties were divorced 7 years ago. Now, the house was always in my seller's name.
Okay.
So the ex was never even on the deed, but they were married at the time my client owned it. Yep. And then they got divorced. Now, in the divorce agreement, it might cover what happens with the property. It might say, I'll pick on Tony and I again. Tony and I are married. I say in the divorce agreement, when I sell the house, I'm going to pay Tony, $50,000 or a third of the proceeds or whatever it might be. Yeah. So a lot of times the divorce will set forth some financial division of the house whenever it's sold.
Okay.
That creates the equivalent of a mortgage on the property, that divorce agreement.
Wow.
So think about it as if Cross Country has a lien on a property while a loan's outstanding. That ex-spouse, because of that divorce agreement, has a lien on the property. Wow. It's called an equitable lien. And when you go to sell that property, as the buyer's attorney, I need to know that lien was paid off. And sometimes we don't have a track record of that.
Right.
The example is the property maybe was never in both parties' names.
Right.
Or, divorce attorneys aren't conveyancing attorneys, so sometimes they don't think about how they do the deeds. They do a deed that says Jack, transfers for $100 his interest to Kim.
Yeah.
And they don't document the fact that Jack was due $50,000. So if I see that deed, divorce and that deed, and the deed doesn't show me the $50,000 consideration that Jack was supposed to get, we can't close. There's a title issue. We have to track Jack down years later and get him to sign what's called an equitable discharge of that interest the court granted him in the property as part of the divorce.
Wouldn't a divorce attorney know that they're creating that equitable lien or whatever you called it?
See, they're not real estate attorneys, and we're not divorce attorneys, right? So in their realm, they've documented the separation agreement. They've laid out how Jack will get paid, when the house is refinanced or when the house sells, and they might even do a deed to help their client. But they're not thinking of title standards. They're not experts in probably reviewing titles,
right?
And so they create these deeds that don't show us whether or not Jack got the consideration he was owed.
Right.
And so I have to tell clients sometimes, you need to go back to Jack, who you don't like, who doesn't like you, who you haven't spoken to in 5 years, and get him to sign this discharge. Because otherwise, the title company won't let us write a clean title insurance policy.
Interesting.
And if I can't write a clean title insurance policy, you're not going to want to finance the loan.
But would have the prior title insurance protected against such a thing?
So if the seller purchased the property and then got divorced, their title policy wouldn't cover that after closing event.
Wow.
So if they owned the property for 10 years together, then they get divorced. Their title policy doesn't cover something that happened in the future, something new.
Okay. Okay.
So that's kind of one issue.
That presents a problem that people are going to potentially have to deal with, and the only solution is going back and finding Jack.
Finding Jack. Get me a copy of the $50,000 check you wrote, Jack. Now, good luck finding that 5 years later, right?
Yeah, no.
So that becomes the problem. And it's not that they just don't know to do this, right? So it's not that they, and you try to explain it to them. Well, I paid him off and I don't want to, But the other thing, so that's one issue.
Well, excuse me, before we go on, how would a future buyer's attorney, settlement agent, find out that Jack had this undischarged?
So when we do a title exam, we not only check the records at the Registry of Deeds, we also check the records at the probate court to see if there's been any divorce situation. So we have to look for that.
Holy cow.
Because sellers don't maybe think to disclose that, don't want to disclose that.
Why would they?
I mean, on my seller intake sheet, when I represent a seller, I ask them, are you married? I ask them, have you been divorced? Because I need to kind of flush that out in the beginning. I don't want to be hit with it a week before closing because the title report comes in from the buyer's attorney last minute.
That's smart.
So we try to flush that out ahead of time because we're seeing in my office between the 4 attorneys that are in my office, this is coming up maybe once a month now.
Holy cow.
Because, divorce has grown over the years.
It has picked up,
And so it's affecting real estate more and more.
Okay.
Yeah.
Wow. Really interesting twist in the subject that I didn't know about.
Yes.
I want to talk about my problems, though. So I would run into more transactional issues where there's a disagreement between parties as they're going to divorce. One is insisting on liquidation. The other can't afford the buy them out, or something's happening where they have to sell the home.
Right.
And my buyers are going in there and I'm trying to finance a smooth closing. And there's all kinds of issues in the transaction. Tell me more about solutions and issues there that can come up.
So the other thing that is for divorce actions that are occurring in the middle of the transaction, one thing that parties may not know is when one party files for divorce or when both parties file jointly for divorce, there's what's called an automatic stay on transfer of assets. The court, by court order, has a stay that says neither party can transfer an asset that's more than $1,000 without some agreement or order of the court. And that's important, right? If Tony and I are getting divorced, and I start liquidating my assets so that, I get them out of my name, then that's going to become a problem later on. So when parties are divorced, if they can't reach an agreement on split of proceeds, is usually the big one. We have to hold those proceeds in escrow, usually with their divorce attorney, until they can resolve it in court.
Got it.
So that becomes the big one, I think, is, well, I put in going back to the operating agreement, I put the 25 grand down when we bought it 10 years ago. I want that 25 grand on the top. No, we're married. We should split it 50-50, and there it goes.
Yeah.
If they can reach an agreement, we'll even make them sign a document saying that they're agreeing to this split.
Okay.
So that later on they can't sue all of us saying, I should have gotten more money.
So we'll, when we have a buyer that's being, is going through separation, we'll require at least that they've taken that step and gotten a separation agreed upon by parties, and maybe even it's got it notarized, and all the attorneys or whoever's mediating it is assigned it as well, indicating that it's accurate. But on the seller side, we're not looking for that as a buyer, a home buyer, financing the home buyer. We're looking for this thing to close smooth and flawlessly.
Right.
And there can be issues with one of the spouses really doesn't want to sell, and they drag their feet. What kind of contractual rights does a buyer have to go and sort of force them to take actions and get things moving and not miss a closing date or have to pay extensions? What does a buyer do to protect themselves?
So a couple of things. One, when we represent a buyer and review the purchase and sale, we'll always include our addendum.
Okay.
Within the addendum, we ask the seller to make certain representations. One of the representations we ask the seller to make is that they're not in the middle of a foreclosure or a divorce or a bankruptcy.
Oh, so we could find out.
So I flush that out before we even sign a purchase and sale, because I want to know, are you in the middle of a divorce? Because that might impact our closing date if we need some court approval.
That's probably where we find out. Very good.
So we try to flush that out for our buyers at purchase and sale stage. Ultimately, an offer to purchase is binding. So even if you get a situation where, everyone knows what's happening, everyone knows the sellers are getting divorced, but a week before closing, one of the spouses who's upset the most says, I'm not doing this, I'm not going to closing, we can enforce the agreement in court. You can go through the court process and seek what's called specific performance.
Yeah.
Now, it's not a fun process, but, within 30 to 60 days, you could be in front of a judge and put some type of lis pendens on the property that basically says you have an interest in the property as a contractual buyer.
Wow.
And that puts some pressure on them to go to closing. And we've done that before.
Wow.
Yeah.
That's not smooth and flawless.
No, and it's not necessarily quick and inexpensive, but usually that step will get the seller to the table. Once a judge says, you're not selling this house to anyone other than Philip and Tony.
Unbelievable.
So hopefully it doesn't come to that. I haven't had a lot of that happen.
Yeah, we don't want to go through any court delays when we're trying to do a home. So before we close out, this kind of brings up, because you're talking about court and you're talking about things that can delay closings, talk about probate. When we're doing a real estate transaction, a buyer's buying a home, and we find out, again, sometimes in the middle of a transaction, because maybe a good attorney is on one side and asking questions about the subject property, we find out it's a settlement, and maybe there was a death and the siblings are liquidating the property or selling the property. I've noticed that can sometimes cause delays because they're probating the property, right, or some way.
Right.
What are some of the things a buyer would look out for as they're trying to close on a transaction when it has to do with not a divorce, but maybe a death, and you're trying to settle?
Right. Well, there's two big pieces we need to look at. One is whether there's someone that has the authority to even sign the purchase and sale agreement. Has the court appointed for that estate a personal representative?
Yep.
And then we have to see what authority they have to consummate the sale, to sign the deed. Because when someone does their proper planning, has a will, they'll appoint someone as their personal representative, but also within the will, they'll give them power to sell real estate.
All right.
That is helpful, because if all we have to know is that someone's appointed the PR, and they're going to be able to take this transaction over the finish line.
Okay.
A lot of times, though, we'll have people that pass away without a will. And so it then becomes a two-step process. One is this person has to be appointed, but also once we have the deal in place, they have to get a subsequent license to sell from the court, to get approval from the court, in essence, to sell the property to our buyer.
Why is that not one and the same?
Well, because when someone didn't have a will, they haven't instructed the world what they want this person to have the power to do. So without a will, you're not telling the world, hey, I want Philip to be my representative and I want Philip to have the power to sell real estate. Wow. And so the court makes you go through a two-step process where Philip's got to apply to get appointed.
Right.
And then once Philip has a transaction, a potential buyer, he's got to go back to court and say, all right, court, will you approve me selling the property to this buyer for this purchase price?
Yeah.
So we do try to flush that out. Whenever we know there's an estate sale, the first thing I'll look for is the will. Do we have a will? Does the will contain a power of sale for real estate?
Right.
So that I know I'm not going to be dealing with a license to sell issue, which can add another month to the buyer's closing window. So I try to at least flush that out.
What do these, like, we're an attorney state.
Yeah.
What do states do where they don't have attorneys doing this?
I don't know.
Flushing.
I don't know.
We're talking New Hampshire, it's right over the border. They can close without a
right. Because even in New Hampshire, you need to be an attorney to go in and represent an estate in front of the court, right?
Yeah.
You can't, even though they're not an attorney state for real estate transactional work.
Yeah.
But if you're not an attorney, you can't file a probate on behalf of a client in court. So it does become difficult where you might have a title company helping you. Then all of a sudden you find out, I need an attorney that's going to deal with this legal process. So, I will say Mass has gotten better. We can get someone, if they have a will, I can get someone appointed, a personal representative in Mass, within usually 60 days.
Okay.
Which isn't too bad.
Yep.
And then if they, for whatever reason, didn't have a will, once I get them appointed, I can get a license to sell usually within a matter of 30 days.
Okay.
So, but still, that's potentially 90 days for a buyer that,
It's not smooth and flawless
no,
like we like it.
no. And that might be issues with locking rates and,
it will be.
Commitment and whatnot.
It's going to be expensive problems for the buyers. And so the buyers might be seeking, if they have the rights, to seek some compensation to take care of those expenses, or, in this market, they might be out of luck.
Right.
Right. It's such a seller's market. So, Philip, we've hit the 30-minute mark, and I just can't thank you enough.
Yeah, my
I have
pleasure.
so much more. I was actually just started thinking more things we got to talk about. But if people want to get a hold of you because they have a situation where they might be doing, might have a friend who might be buying a home with another friend, and they want to mention you, how do they get a hold of you? Yeah,
so you could call the office. It's 978-250-3800. So 250-3800.
Okay.
Our website, we've got a decent website where they can reach out to us through the website. It's eliopouloslaw.com, which is not a great thing, but I'll just spell it. It's ELIOPOULOSLAW.com.
Easy.
We're in Chelmsford, so you can find me probably.
Yeah, easy. I certainly do. And I really appreciate your time.
I appreciate you having me, and I appreciate you doing this because I think it does do a great thing to educate the buying and selling community. So Thank you for doing it.
This is great. So tell me, there were a few other things I wanted to bring up. One of them had to do, I think, with contracts. And now I forgot the question. What the heck was it? It came up while you were talking. And now I'm not going to remember. Massachusetts, New Hampshire. And you're licensed in Mass and New Hampshire. Do you do business in Maine too? Have you ever?
So we can do, we'll assist clients in Maine that maybe we do trusts for. If they're putting a vacation home in. You know, we try not to do real estate closings for Maine. We do them in New Hampshire. We're licensed with the title insurance companies in New Hampshire to do residential and commercial lending transactions there, which is great.
Okay.
But we'll help clients with vacation homes if they're in a different state to help them, kind of wrap those up into an estate plan. So we can do that.
So I have a new client reached out to me and said, he's going to buy a home. He's got a contract under agreement, or at least he got the offer accepted, and he needs an attorney. What is the process you take a new client through when you onboard them? Like, what are you doing? Are you asking them questions? Are you just sending them, something? Are you getting this in Massachusetts, for example? You're signing you're getting a purchase and sale written up. Tell me the steps to engage with a real estate attorney, and what do you do with clients? When are you inserted into the scenario?
Right. So typically we get inserted once they have a signed offer. Usually that's when they're starting to talk to someone like yourself for financing, or you're saying, okay, great, you found the house, you got it under agreement. Now we need an attorney that's going to close for us.
Right.
And you'll sort of send them maybe to us to review the purchase and sale agreement. So, we always say to people, don't be afraid to reach out to an attorney before you present the offer. Okay. Is there something that you're missing? Because once you put something in an offer, it's hard to take it back,
Yeah.
And so as an example, did you leave yourself enough time for financing? Sometimes people put very aggressive dates, purchase and sale in 5 days, financing in 2 weeks, closing in 3 weeks. So I always try to get clients to, tap into the wisdom of the lender, the attorney ahead of time. But often they get the house in agreement, then they're reaching out to us. We'll always have a conversation with them, kind of introduce ourselves, explain our role. And we go through the purchase and sale agreement. We make changes to protect them. We add our addendums.
How is that generated? The P&S is an addition to the contract.
Yeah, great question. So in Massachusetts, from a sort of a historic perspective, the seller typically generates the first draft of the purchase and sale.
Seller's attorney.
Usually it's an attorney that does that. So, brokers over the years have been wisely shying away from doing the purchase and sales because it creates some liability if something's missed. Right. So they prefer to sort of pass it off to the attorneys.
Yep.
And so it's just become common practice in mass for the seller's attorney to prepare the first draft. And then we as buyers attorneys will review it, add our changes, add our addendums that we talked about earlier. And, kind of go back and forth. Sometimes it's a little bit of a negotiation. We keep the buyer abreast of anything that's material that maybe we wanted they wouldn't agree to, and what's the risk. But again, more often than not, we want to make these deals happen, right? So I'm not going to get hung up over my 1 in 1,000 risk in my head as an attorney. I'm trying to protect the client, but maybe they don't want to agree to it on the other side. We got to be wise.
We'll weigh it, right?
Yeah, weigh it out. And we'll get it in final form. They'll get it signed up, and then we start to do our due diligence from there.
As the settlement agent, you begin the process of examining title, researching, bringing up issues. And we could probably talk for an hour about what you look into. But let's keep it on the surface. I'm thinking in terms of what is a buyer going to expect when they start talking to an attorney. Some people are afraid to talk to attorneys just from what they see on TV or something. What are you doing with them? You call them up, hi, I'm an attorney, and what? Questions?
I want to call them up. I want to introduce myself. I want them to know they can reach out to me. Awesome. I let them know, hey, I've done 4,000 of these. This might be your first or second one. So no question is. I don't ever feel like there's a question that you're
right.
Embarrassed to ask because you haven't done this all the time.
Right. That's cool.
I also want them to know pricing. Like sometimes people they're afraid to ask, like, what do you charge? And I like to just tell them up front, you know what I mean? That we charge flat rates for these transactions. And this way, that's not something that's in the back of the mind. What's this going to cost me? And, the good thing is with the loan estimate, most of these things are all disclosed, which is nice now for them. But even a seller, I want them to know how we charge as well. Okay. So, and kind of just view it as a client for life. That's my hope, is that it's not a transactional client, that hopefully this relationship will go beyond the closing. So, we'll obviously meet with them on the closing. We'll reach out to them after the closings, kind of check out on how things are going. And that's just there for, when they need us.
And I can say, since you and I have been doing business so many years, I can see a lot of clients coming back to you for a lot of different reasons, whether it's estate planning or lot line infringements or issues they have with the property rights or something like that, easements, understanding easements. Boy, we could talk about that as well. There's some things that have come up with easements in the past. So, but you're going to sit down with them in the beginning and interview them. You'll probably be asking questions about, are you married, or
Right.
you're trying to find out information about their situation, their estate situation. How are you going to hold title? Do you bake all that up front before you're doing this contract, or do you ask that as you get closer to closing?
Well, so I'll have some limited time when I'm trying to get their purchase sale squared away, but a lot of times it's hard to know whether people are married. People are keeping their professional names sometimes.
Right.
So, but I will ask, at some point in the transaction, I'll look at the loan application. That sometimes will tell me, right? So but if they're not married, I will bring it up and say, hey, listen, there's a couple of things to think about. How do we want to take title?
Yep.
What tenancy do we want to put on the deed? Have you thought about putting together an agreement?
So smart.
Yeah. So I try to do that because they don't know maybe to even think about it. It's not something that's on their radar.
Right.
So we do try to, it's funny. We do try to flush things out, and I'll even ask them because I'll say this too. Sometimes when they're not married, I'll ask them at the closing table, do you plan on getting married? And usually it's the guys giving me this look like, why did you bring that up?
You jerk.
Yeah, you jerk. But the reason I bring it up is because once they get married, they can change the tenancy on the deed from joint to tenants in common, and that provides them with some statutory protection from each other's creditors. So I want to put that on their radar. I'm not asking because I want them to get married.
Right.
I want that if I know they're getting married 6, 9, 12 months from now, which is common.
Yes, it is.
I want them to get back to me so we can fix the deed for them. So that's kind of why I'll even bring that up, usually at the closing table.
Very smart.
It's not easy to bring up, though, Tony, I can tell you.
Very smart.
It's like,
just fascinating. So I've closed on my home. I'm a first-time home buyer. What things could I reach out to you, the closing attorney that helped me after closing, to get help with? When should I think I should call Philip about this?
Well, I think everyone who owns real estate needs to have a basic estate plan, right? Because whether you own it individually or with someone else, if you ever get sick and you can't write out the bill to pay the mortgage each month, you need someone who could maybe sign a check for you. So, power of attorney would help with that.
Okay.
But also a will. God forbid someone passes away owning real estate. We talked about that. Yes. If they don't have a will, it's harder to probate the estate. And I also then need to go through a subsequent license to sell process. So a will becomes very helpful there if we're real estate owners. So, I will talk to them about, hey, listen, you've, especially the younger folks, you got this is a great step in your life and your, in many cases, your biggest purchase you'll ever make.
Yep.
And now let's protect it with a basic plan.
Okay.
So I will talk to them about that without sounding too salesy. I want them, but I want them to know they should think about this.
I totally agree. Yeah, that should be something. So estate planning, obviously.
Yep.
Disputes with their neighbor, things that have to do with the lot lines or use of property. Are those things they come to you about? Is it you the type of attorney that would?
Yeah, so they will. I mean, we do what's called a plot plan as part of the closing, which would flush out maybe 90 to
my shed's on your property type of thing.
Yes, or the driveway's encroaching one way or the other. So the beauty of the plot plan is we can flush out sometimes like 90% of those issues, but there's certain times where after closing, someone builds something new and there's a question of where it is.
Fence. Where are you putting that fence on the property?
Yeah. And those are the toughest things, right? It's your neighbor. Yeah. You got to see them every day. You got to live next door to them. Yep. So I always try to, I always caution people before is there a way to resolve it? Is there a way to live with it? Because once you start litigating with your neighbor, that's not
the same.
Who wants to live next door to that, right?
No. Yeah.
So more often than not, I'm trying to talk people out of doing things when it comes to their neighbors.
It's smart
because
that's a good thing to do.
Yeah, I don't know. Well, it's just I know how it's going to look at the other end. When win or lose, they have to live next door to this person and see them every day. every
Very true.
weekend, and that's just not a pleasant living experience.
Yeah, so smart. And what if we've got a shared driveway? So lots of transactions here in Massachusetts, New Hampshire, shared driveway
Yep.
with a neighbor. You're closing on this home. The driveway is shared by two parties. There's no written agreement in place at the registry saying, you got to take care of this and you,
Yep.
what should neighbors do about stuff like that?
Same thing as we talked about with buying property together. Ideally, in a way, it's like joint ownership, right?
Mm-hmm.
You own this driveway together. And so in a perfect world, you have a very simple agreement that says how we're going to maintain it, repair it, replace it if necessary. And it's going to make it easier for both sides on a resale of that property to find a buyer who knows that
and
agreement's
financing.
in place, and financing.
Yeah.
So I think it's to everybody's benefit, even if it hadn't been done the right way, to have it done at some point, because it's going to make things smoother when they sell it someday.
If it's on my property and my neighbor has to share my driveway, is that different from the driveway is right on the lot line? You own half of it, I own half. We got to take care of this thing together. Like, is there a different way to look at it?
Yeah, I mean, usually it could cover both scenarios, because at some point the driveway probably veers into the abutting house, right? So maybe most of it's on my land, but part of it goes on to theirs. And I don't want them coming onto my land without knowing I'm protected.
Yep.
So I want the agreement, even though it's on my land, I may want the agreement because I want them to pay for half the maintenance. I want them to indemnify me if one of their invitees gets hurt. I don't want to be on the hook for, like, someone slips and falls going to your house. You take care of that problem. They're your invitee, not mine. So we can cover even things like that.
Does somebody buying a property with a shared driveway have an obligation to tell their insurance agent this? I wonder.
That's a great question.
Yeah,
I mean,
liability.
it wouldn't certainly hurt, right? The more you tell your insurance company, the less likely they can deny a claim for failure to know. So
I didn't think of that.
even when, like, we do estate planning and you put your house in a simple trust because you want to avoid probate, I'll tell you to contact your insurance company, tell them you put it in a basic revocable trust, just so, out of the abundance of caution, just so they couldn't try to deny a claim because Tony didn't tell us you changed the ownership of the deed and we're not going to cover the claim now. So I think it's always worth sending a little certified letter or an email to your insurance agent so you've documented the information to them.
Outstanding.
It's like my wife. She was dying to get a trampoline. I go, we can't get a trampoline. Amanda Lucia, great insurance company, they won't let me get it because they don't like policy. She's like, well, just we won't say anything. I'm like, well, then we won't be covered. That's no good either. So
Amanda and my dad, both of those parties
said no.
My dad was a professional gymnast, and we grew up on trampolines at the Coast Guard Academy where he taught, and when I went to camp, we had trampolines. And boy, oh boy, when my wife brought it up one day with him, definitely not something you want to get into a conversation with because you can really get injured on those. And then talking to Amanda about our home insurance policy, she's like, do not do that.
Right. You don't buy a dome and pincher or get a trampoline. It seems to be the two biggest no's on insurance.
Philip, thank you. This was a really great. Well, thank you for joining us today on the Real Estate Solutions Lab podcast. I hope we can have you back. I've got so many more questions to ask. We run out of time now, but
anytime.
It'll be great to have you back and talk about some other things in the future. So thank you.
Thank you for sharing your knowledge as well on this.
All right.
Appreciate it, Tony.
Thanks a lot.
Bye-bye.
Bye.